Welcome to the Protect Your Nest podcast, hosted by me, Attorney Brandon Lawrence. Here, we're taking the mystery out of estate planning and probate with honest conversations that make complex topics easier to understand. Everything from wills, trusts, healthcare directives, and elder care planning. It's all about helping you make the informed choices for yourself and your loved ones. Let's talk it over. Hey, welcome to another episode of the Protect Your Nest podcast. I'm Louisville estate planning attorney Brandon Lawrence. Ladies and gentlemen, we're talking about assets today. We divide assets up into two categories, probate and non-probate. Probate is a process. I'll give you the definition of probate, quick one. Probate is a process when the court will supervise the legal process of validating the will that you write, settling debts, and transferring property. Before you die, there's no reason not to determine who gets your assets once you die. Now, there's a couple more words I'm gonna give you a definition of, and this I'm gonna try to break it down a bit simpler for you. So you've got everybody knows you've got wills and trusts and other mechanisms to leave your assets to people prior to your death or once you die. So that's called that's going to be called obviously those are called wills and trusts, things like that. So if you do not have a will and a trust, you die what they call intestate, okay, without a will or without some mechanism that's going to say, hey, this is who my property goes to, my assets go to. Now, you don't want to die intestate, all right? You do not want to do that, because what happens is if you die intestate, all the property that you have, who it goes to is going to be determined. It's already pretty much predetermined who it's going to go to. And that's covered by a statute in Kentucky. Generally, to get into it, is KRS, Kentucky Revised Statute 391. All right, that's going to cover intestate stuff. And that's basically if you're married, you're gonna go. Your property is gonna go half to your spouse. If you've got children and married, half to your spouse, and the other half is going to be divided by however many children that you have. Okay, so that that the law predetermines that. But if you want to be if you want to take precaution and have a plan in place before you pass away, then what you can do is you can you can make the decision on who you want to give your property and your assets to. All right. And then that comes in, that's where we come in with the probate and the non-probate stuff. So having going through you, and then once this happens, once you pass away, you probably don't want to go through probate, or you want to go through a small portion of probate as you can, because even the will has got to be probated, right? Even if you write a will, it's got to be probated, and it goes through the courts. So a lot of people believe that, hey, if I got a will, you just, you read it, stuff goes to people, and that's it. But no, that's not what happens. The will has got to be, as I said previously, the will has got to be read. The will's got to be processed by the court. Okay, so but if you put your property in any type of trust, revocable or irrevocable, that's the best way to get that property and those assets directly to the people that you want it to go to. That process is quicker. If you got some type of trust mechanism, it's just quicker. As I said, it goes the assets are distributed directly to the people that you wanted to go to without the court intervention. You avoid the probate. You don't have to worry about court. Court doesn't go. Court doesn't determine anything because you've already predetermined it. Now, it's that, and it's a private proceeding. Okay, if you don't want a bunch of people in your business, the trust is the way to go, because wills have to be wills are a public record because they've got to be filed in court. And the process possibly could be drawn out, take a little bit more time, and cost you more money. Because, and another thing, people like to contest wills. But I mean, you can put mechanisms in there to avoid that, and to prevent, well, not prevent, but have, lower the chance of them contesting your will. Okay. So, but the trust thing probably is the way to go. You're gonna lose less of your assets. Um, the time is gonna be cut in. No, I don't know if it's gonna have, but it's gonna be lowered. Uh, whether you're gonna get how you're gonna distribute your assets and your property. So let's get into which assets are probate assets. All right. That's going to have to go through the court. Real estate and land is titled only in your name are probate assets. All right. Checking accounts, savings accounts solely in your name with no beneficiary designated are probate assets. Personal belongings like jewelry, that Da Vinci that you've got hanging on above your kitchen sink, vehicles, furniture that you own alone are probate assets. If you've got a business, sole proprietorship, or if you own shares in a business and that business doesn't have like a succession plan or a buyout agreement, those are probate assets. And if you have an insurance policy or retirement account that names your estate as your beneficiary, some people do that. Some people don't name individuals; they name an estate as the beneficiary. Then that policy or account is going to be considered a probate asset. I hope you see some type of theme that's developing here, right? If you don't leave your property to someone, that's going to be probate, and it's going to be a drawn out process. As I said before, it's going to take away more of your assets that are going to be able to be distributed directly to a particular person. I mean, you can leave your stuff to your dog if you want to, um, and it'll go. It'll give them more. They'll be able to have more kibbles and bits, um, than if you just let it go through the court and kind of, I wouldn't say, yeah, and just have a laissez-faire attitude and say, hey, it's gonna get to them. But if you want your property to go to a particular person quickly, and have them have access to more of it, and have it be a private affair, then you want to go the non-probate route, right? So, you can avoid, like I said, you can avoid having the court decide anything about your assets if they're considered non-probate. And we'll go over a list of things that are non-probate. Assets placed in revocable or irrevocable trust are non-probate. All right. Payable on death or transfer on death accounts are considered non-probate. And examples of these accounts are bank accounts, CDs, not the for the baby boomers in the other generation, not the CDs you put, of course, not the CDs you put in your car like Bon Jovi or whatever, but certificates of deposit and brokerage accounts that have beneficiaries are non-probate. Property jointly owned that automatically transfers to the surviving co-owner upon your death is a non-probate asset. So it's not just enough to have something, um, I guess you and a partner own it. You gotta have a mechanism in there that says, like a joint right of survivorship, something of that nature, that upon your death, it automatically goes to the other person that owns it. So there's no in between, there's no middle person, right? Um, Life insurance proceeds and retirement accounts that name an individual or entity as a beneficiary of non-probate assets. And pensions, annuities with named beneficiaries are non-probate assets. So, of course, anything that you have, you just leave it to somebody. I mean, of course, I think on another episode, we talked about a little bit about briefly, when you go to your job, you get your 401k and you name a beneficiary. Who are you gonna give the proceeds of your 401k to? Something happens to you, that automatically puts it in the non-probate category because that's going to take precedent over anything else that's written after that because you've already documented who you want that to go to. And that's, of course, with any investment account, your life insurance, which is pretty basic, that you do that when you sit down and take out your life insurance policy. Um, so those things, I don't know if the courts or whoever made the legislature, whoever designed these rules, if they want, if they did it with a specific purpose, but or with a specific intent, but the effect is you want to leave something to somebody, which is a good thing. You don't just want your stuff hanging out there. I mean, you worked for it. And a lot of times you've got a family or you've got someone that you can leave these things to. So go ahead and document it and make sure that that before you pass that you're giving it to who you want to get it, or get it in somebody. All right. Or if you've got some personal things, give it to them while you're living. I mean, of course you're not going to give them something that's functional and you're using every day, probably, because you're going to need that. But I mean, if you got some antiques or collectibles or whatever, or like a painting or something physical, or a vintage car, whatever, give that to, and you're not using it, give that to whoever you want to have it before you die, if you can. Or the worst case scenario, have it documented, written down that that you're going to have it written down who it's going to go to. It saves a lot of problems, and it may save a bunch of drama. It disincentivizes. Well, yeah, it's a disincentive for people to contest anything and argue over, simple things when it boils down to it. And it's the right thing to do, and the it prevents anybody else of getting in your business. It keeps it private, and it's done and it's over with. And it's pretty simple, you know. And those are just a couple things. You got the definitions of probate, intestate, non-probate. You kind of get a picture of what you need to do before you come in and talk to someone like me to have a plan and flesh it out in a roadmap of what you want to do. So you have a little bit of prerequisite knowledge of how to get there. And that's what we're here for in each and every episode, the ones preceding and the ones that are to come. And we're glad you're staying with us. You can go back and watch some previous episodes, get a little bit more insight if it's something that I haven't covered on this one. And if it's something that I haven't covered before, we're going to try to cover it in the future. We thank you for watching and being a part of the Protect Your Nest family. I hope you found this particular episode interesting. And like I said, be sure to check out all the previous episodes and future ones on my website, lawyerforthecity.org. You can check it out on YouTube or wherever you get your podcasts. It's always readily available, and I'm here for you to provide some information. And I'd love to talk to you one-on-one, whether it's via Zoom or in person, to help you protect your nest. So if you're ready to protect your nest, I'm estate planning attorney Brandon Lawrence, the lawyer for the city. Until next time, let's talk it over. That wraps up today's episode of the Protect Your Nest podcast with me, attorney Brandon Lawrence. I hope you picked up a few ideas to help you and your family plan with confidence. Be sure to like and follow so you won't miss our next conversation, where we'll continue exploring the topics that matter most for your family's future. Until next time, let's talk it over.